This is Bloomberg Law with June Grasso from Bloomberg Radio.
We're in the business of complying with federal court decisions. And when they told us that we needed to draw a second majority black district, that's what we did.
That's how Louisiana Solicitor General Ben Aguinaga summed up his state's position in the challenge to its congressional map at the Supreme Court. It's a case that involves the interplay between race and politics in drawing political boundaries, and the oral argument signaled a deep divide over the use of race in redistricting. At issue is the map drawn by Republicans to simultaneously create a new majority black district as required by a court order and protect incumbent Republicans, including House Speaker Mike Johnson. And the justices seemed divided over the question of whether race was the predominant factor driving the new map. Chief Justice John Roberts called the new district a snake that runs from one end of the state to the other.
And you think the drawing of this district was not predominantly based on race?
I mean,
it runs from one side of the state, angling up to the other, picking up black populations as it goes along.
But the three liberal justices suggested the district's shape was a product of politics, something the court has previously said is a permissible factor. Here's Justice Ketanji Brown Jackson.
The reason why we're looking at a snake-like map rather than the compact map is because of political considerations.
Politics is the only reason that the state chose that map over the compact maps.
Joining me is elections law expert Richard Briffault, a professor at Columbia Law School. Rich, explain the issue before the justices.
This is a very strange and unusual case. In order to discuss the issue, you actually have to go back to a prior case. And so a couple of years ago, a lawsuit was brought in Louisiana by black voters claiming that the congressional map in Louisiana discriminated against black voters because they were underrepresented, that it had a discriminatory effect. Louisiana is something like one-third black. The state has 6 congressional districts, but only one of them had a black majority. The plaintiff said it was relatively easy to create a compact district that followed traditional districting patterns in part of the state that would create a second black majority district. They went to court and they won. They won a preliminary injunction. It was a 5-day trial, lots of exhibits, lots of witnesses. They won at the district court, and that was subsequently affirmed by the Fifth Circuit Court of Appeals, which is itself a pretty conservative court. The question happens what to do next, how to redraw the map. The plaintiffs had a map that they liked, which would have created that second black majority district. But the usual rule is to allow the legislature a crack at it and to see if they can do it in time. Otherwise, a court will create a map. So this went to the Louisiana legislature. And the governor said, we need to do a map. We would have liked to fight this case more, but we've already lost twice in the district court and the Court of Appeals. We need to write our own map rather than having a court impose one on us. When the legislature sat down to draw a map, though, they had a problem because it's a Republican majority legislature, Republican governor, Republican delegation, and several of the Republican members of Congress in Louisiana are very powerful, including the Speaker of the House, the Majority Leader, and somebody else they really liked. And so they decided, the legislature in Louisiana, that they would sacrifice one Republican district, but not the district that made sense in terms of the plaintiff's original lawsuit seeking a black majority district. They kind of cobbled together a new district that stretched across the state and got rid of a different white Republican congressman in order to preserve the districts of the Speaker, the Majority Leader, and the member of Congress who they favored. So this new district is a black majority district that comes out of this lawsuit. Now, some white plaintiffs have sued, claiming that this district is unconstitutional because it's unconstitutionally race-based, that it's a racial gerrymander, that the decision to draw this district was primarily based on race, and the Supreme Court has for some time said that that's unconstitutional. The state is defending it, as are the original plaintiffs, the black voters, on the grounds that, no, it's not racially predominant, it's really politically predominant. The reason this district has this odd shape is not really because of race, but because the legislature wanted to basically protect Republican incumbents. And a different lower court than the one that heard the original case said, no, this is racial predominance. The only reason this district exists is to create a black majority district. And that's the argument before the Supreme Court. And it's a kind of an odd one. The Supreme Court has said in the past that if something is drawn primarily from the basis of race and there's no other justification for it, then it may be unconstitutional under the Equal Protection Clause. But if it's done primarily for party, that's partisan gerrymandering, and you can't challenge that. And the question of whether something is based on race or on party has really been before the court several times, but that's kind of what they have to decide here. Is this district primarily based on partisanship, because that's why the legislature drew it the way they did it, or is it based on race because they wouldn't have been drawing a new district at all but for the earlier judgment that Louisiana needed a second black majority district?
What use of race in drawing maps is permissible?
You can use it in a remedial sense. I mean, obviously you couldn't remedy Voting Rights Act violations unless you took race into account in drawing the remedy. But the question is sort of, when does race too much? That's where the court has settled out over the last several decades. You can't ignore race, and sometimes you have to take race into account. But if you give race too much attention, they use the notion of predominance, then unless it's justified by something else like the Voting Rights Act, then it violates the Equal Protection Clause.
There's a tension between the court's precedent in those two areas?
In a sense. I mean, the court has said you can use race, you just can't use it too much. The justification for using race is to remedy another violation, like a Voting Rights Act violation. If a court concludes that the state's districting pattern discriminates based on race or has a racially disparate impact, which is what happened in this case, then redistricting is based on some attention to race. The concern in the plaintiff's claim in this case, the white plaintiffs, are the district that they drew kind of stretches across the state, and what it does is it picks up, pockets of black population in different parts of the state to create a black majority district, and that makes it look like a racial gerrymander. The state's defense, as well as the defense by the original voting rights plaintiffs, is, well, the reason it stretches across the state is really for partisan purposes, because we didn't want to put it in the area that the black plaintiffs originally wanted, because that would have gotten rid of an incumbent that we like. So we did it this way to get rid of an incumbent we didn't care about so much. And the voting rights plaintiffs also point out that much of the district does include much of the district that they had originally proposed. But it is true, it is the kind of district that does stretch across the state in a way that is often drawn criticism.
Did you hear a divide between the conservative justices and the liberal justices on the use of race in this case?
Well, I think the conservative justices, who I think were, yes, they were troubled by it, I think they were slightly frustrated by the fact that the state, Louisiana, a conservative Republican-led state, is defending the map, and the state basically kept making the point, the reason we did this is because we had a judgment against us. And I think some of the conservatives maybe kind of wondered, maybe you should have challenged that. Do you agree with that judgment against you? And, of course, the state's position is, no, we don't agree with the judgment against us, but we lost twice, and we didn't want the courts to impose a map on us. So I think the conservatives were somewhat frustrated in this case because they're not directly reviewing the original lower court case that said Louisiana violated the Voting Rights Act. They never took that case. What they're reviewing is the state's remedy, in which, although it's clear that race plays an important role in their redoing the map altogether, I think the state's argument was that this particular configuration reflects our political judgment that if we had to sacrifice one white Republican congressman, we chose Congressman X and not Congresswoman Y.
There's been a lot of talk lately about the standoff between the Trump administration and the courts, and the question of whether the Trump administration is actually complying with court orders. Did you see subtle references to that during the oral arguments? You had the Louisiana Solicitor General saying,
right,
we're in the business of complying with federal court decisions. And Justice Jackson clarifying with him later that the court order was the reason why Louisiana drew up the map, and it didn't matter whether the order was right or wrong.
There's no dispute that the court's order was the reason that Louisiana did the new map, right?
Mr. Grime can correct me if I'm wrong, but I don't think so, Your Honor.
And the question is whether or not the fact that you had a court order was a good enough reason for you to do it. Is that what you understand the basic question to be?
That's correct. Not just one order, but two layers of orders. Yes, Your Honor.
And I guess I'm still a little confused as to why it matters whether the court order was right or not. You were still being compelled by the court to do what you did in this case, correct?
That's correct, Justice Jackson.
That was my impression as well, is that the Solicitor General was being very good about saying, we follow court orders. We lost once, we took an appeal, and then we follow the court orders. And some of the justices were pressing him, well, what if it was completely wrong? Would you follow it if it was completely wrong? And he was saying, we're not going to get in the judgment of deciding whether it's completely wrong. We didn't like it. We defended our position. We thought we were right. We took an appeal. We thought we were right on the appeal. We lost the appeal. And I think our solution was, instead of keeping fighting, we want to be able to control our own map.
Coming up next on the Bloomberg Law Show, I'll continue this conversation with Columbia Law School professor Richard Briffault. We'll take a look at how the justices might rule. I'm June Grasso, and you're listening to Bloomberg. The Supreme Court justices displayed a deep divide over the use of race in redistricting in a case involving Louisiana's congressional map that created a second majority black voting district. At issue is the new district, drawn by Republicans, which runs a jagged course over 250 miles from Shreveport to Baton Rouge. Louisiana Solicitor General Ben Aguinaga said the state was simply abiding by a court decision and was entitled to flexibility in doing so, as it tried to ward off the prospect of a court-imposed map. His argument seemed to resonate with much of the court, including Justice Amy Coney Barrett.
I mean, is it also because of the position that it puts the state in here? I mean, it's not just a matter of your obedience to the federal court order, which I appreciate, you would be obedient to the federal court order, but it's also that if you had continued to litigate in Robinson, you risked having the court-imposed map. And so it's really your litigation risk that's part of the calculus here.
I've been talking to Professor Richard Briffault of Columbia Law School. Rich, do you have any inkling for what the court might do here?
Well, first off, never predict the Supreme Court. But I think there seemed to be enough understanding of this by at least some of the justices that you might say the justices in the middle, like Kavanaugh and Barrett, of the tight squeeze that the state was in, and the idea that the state should have some space, some discretion to accommodate a court and also to accommodate its own political preferences. I mean, Gorsuch, Alito, and Thomas were clearly very unhappy with this map. Roberts said very little as far as I could tell. And I think maybe I'm overreading it, and you never know with them, but I think there was some sympathy I think I saw in Barrett and Kavanaugh for the situation that the state was in. You have the impression from the very conservative justices and even from some of the justices in the middle that they may be looking to rethink the Voting Rights Act and rethink how much attention race should be given in districting. But my impression is, at least for some of the justices, may be realizing that this is not the vehicle for that, because given the state's defense is so heavily based on partisan considerations, which I think they were pretty good at showing were real and not pretend.
Just tell us a little bit about how the Supreme Court has sort of been chipping away at the power of the Voting Rights Act.
Well, I mean, candidly, the one case that's most relevant is the case that they didn't, the Alabama redistricting case, Milligan, which was decided 2 years ago, and this case follows immediately on it, where by a 5-4 vote they actually upheld a lower court judgment that the Alabama congressional districting plan had a racially disparate impact and that it denied fair representation to black voters in Alabama and required the creation of a second black majority district in Alabama. It was that case that I think the lower courts relied on in the earlier version, the first round of this case, to find that Louisiana was in violation of the Voting Rights Act, and maybe why the U.S. Supreme Court didn't take the Louisiana case as they had just decided the Alabama case. That was a 5-4 case, and it was a bit of a surprise because they'd previously issued a stay against the lower court order in that case, so that he allowed the old map to be used one more election. So I think, it's in other areas the court has certainly cut back. They have made it now almost impossible for plaintiffs to bring Voting Rights Act claims challenging various mechanisms like voter ID and issues that make it harder for people. What the claim is that certain, voter registration and voter ID rules the disparate impact on black or other minority voters. That Supreme Court in a case called Brnovich some years ago threw that out. Now, more than 10 years ago, they got rid of Section 5, which was the preclearance requirement, which was probably the most important piece of the Voting Rights Act, requiring certain states which had a very bad track record of racial discrimination to get their voting law changes precluded by the Department of Justice now about 10 years ago. And they've been sending signals, at least a number of justices, that they are troubled by the degree to which the Voting Rights Act is being used to challenge voting laws, voting rules, and things like districting plans. But right now, the most recent case, that Alabama case, is one where they actually are continuing to enforce it. Some people are seeing this as another challenge. I think if the court is going to start cutting back on the role of Section 2 of the Voting Rights Act in challenging districting plans, I'll go out on a limb and say this is probably not the case, but you could imagine it happening in the not-too-distant future.
I mean, you were surprised by that Alabama case. I was stunned, and
right.
I'm wondering if it's an exception rather than the rule, because it sort of stood out.
Right, but this case is an immediate follow-on, and it's not even this case. It's the case that this case builds on. The thing is, this case is not a direct review of that case. In some ways, it is arguably an indirect review of that case. But the Louisiana case, basically saying that Louisiana needs to create a second black majority district, was very, very similar to the Alabama case. So it would be a real stretch, I think, to say that the district is racially predominant when the state was acting because of a court order, and the factors that led to this particular district design were clearly political, or at least to some degree political. I mean, there was an interesting bit of a dialogue between Justice Kavanaugh and one of the advocates about, how do you decide whether something is racially predominant or politically predominant? Is it 50-50? Is it 60-40? Is it 70-30? And the Solicitor General for Louisiana is saying, we think this is about 70% political, and that if it's in the 60-80% political, it ought to be seen as politically predominant and not racially predominant. There was an interesting effort. How do you decide?
Let's listen to part of that exchange.
So the rule I think you want is political considerations are fine to take into account in doing the map, the second map. In 50s, kind of a floor on that?
I think so. I mean, this court has never spelled out what substantially addresses means as a numerical matter. And to my mind, if I'm between 60 and 80%, I think that's substantial, but obviously a judgment call for this court.
And it struck me that the Solicitor General of Louisiana did a very good job of basically saying all we're doing is trying to abide by a court order in a way that satisfies our internal political needs.
In light of that, would their decision have any impact on future cases?
Since it's not a direct review of that Louisiana case, I don't know. I mean, I think in some ways it ratifies the idea that it's consistent with the Rucho case, which is that partisan gerrymandering is just fine. It follows on that. I mean, in some ways this is an odd partisan gerrymander because it wasn't Republican on Democrat, it was Republican on Republican. One way or the other, a Republican district was going to go. But so you could maybe, instead of saying partisan gerrymandering, you could call it political gerrymandering. But this is clearly a case where political forces were very important and leading to a somewhat oddly shaped district. I mean, the trick in the case is presumably if the plaintiffs have come forward with this district, they may very well have lost because this is not the kind of compact district that respects political subdivision or, local community lines that the court likes. But the plaintiffs didn't come forward with this district. The oddity of this case is the plaintiffs were able to show the district court in the first case that you could create a very straight, very compact district that respected community lines and subdivision lines better than the state's original plan and create that as a black majority district. That persuaded the district court. But then when the state went and, decided to do the remedy, they came up with a completely different district. Now, that's not the plaintiff's fault. The plaintiffs are still defending what they did because they said, well, we still get a lot in this. It's still 70% of our original district is in this district. But, it's not the one that the plaintiffs had asked for.
And will the court's decision here have any effect on the congressional map in the midterms?
Well, I think this district is already in place. So in some ways, the Democrats picked up one seat in Louisiana because I think this map was used in 2024. So if it's reversed, then there's a likely Republican pickup of one in Louisiana. Depends. But so I think it's already had a one-seat partisan effect, as the Alabama redistricting did.
So the federal government, where did the Trump administration stand on this?
They removed themselves from it. The Biden administration was defending the map. The Trump administration, I think, in the end, didn't take a position.
I have to say this is a very confusing, perhaps because of the complex procedural history, perhaps because the state seems to be in an odd position.
This is a very odd case. And so I think this is one that may not have a lot of law. I mean, well, if the lower court is reversed and the state's map is sustained, because what happened in this case is the lower court in the second set of litigation said, no, this map is an unconstitutional racial gerrymander. If the lower court is reversed, then I don't think there'll be much of significance. The lower court is sustained, then I think it's going to be very weird, because then it means that any time race is a factor at all becomes a problem. And so it's, again, almost impossible to read the Supreme Court, but at least based on the way the questioning went by, at least by Barrett and maybe Kavanaugh, they seem to sort of realize that the state was between a rock and a hard place, and they might be inclined to just leave it alone.
And the Solicitor General was really strong and pointed out over and over again that Louisiana was complying with a court order.
You know, if the state had just created this district to create a black majority district, it would be Shaw v. Reno, and it would be thrown out. But, you know, they did it because a court forced them to create a district, not just the Department of Justice, which was going on in Shaw, which was because then it was at pre-clearance. But a court said you have to create a district, but we're going to let you decide where it is. And it's so hard to say that this was more race than party, or more race than politics, I should say politics. And the court has said politics can be a factor, and they threw out challenges to partisan gerrymandering.
So as in so many other cases, it seems like the decision will depend on the justices in the middle. Thanks so much, Rich. That's Professor Richard Briffault of Columbia Law School. The Trump administration is escalating the legal battle over the deportation of alleged Venezuelan gang members. The government is refusing to hand over flight data requested by federal Judge James Boasberg, now citing state secrets and national security risks. At the same time, a 3-judge appellate panel is weighing whether to continue blocking Trump's invocation of the Alien Enemies Act to fly the reputed gang members to a Salvadorian prison. Joining me is Bloomberg legal reporter David Voreacos. For 10 days, Judge Boasberg has been trying to get this information about the 2 flights. And now the Trump administration is refusing to hand it over because of national security reasons, state secrets.
The Justice Department says that by handing over the information that Judge Boasberg is seeking on these 2 flights to Venezuela on March 15th, that would compromise national security and foreign policy. And in a filing late Monday night, they said essentially that they are exercising the state secrets privilege, and they would not give the information to Judge Boasberg, even under seal or in his chambers.
Judge Boasberg was formerly the presiding judge of the National Security Surveillance Court. So he's been there before.
He has a lot of experience in handling national security secrets, and he knows what he's doing. So he actually, in an earlier filing, said, are you going to invoke the state secrets privilege? And if so, please state the reason why, which is essentially what the government did last night.
Just to be clear, these are flights that have taken off and landed. And there's been reporting by a couple of news organizations tracking down what times they actually took off and landed.
Right. But the judge actually wants the government to state it to him directly. When did the flights leave? Where did they leave from? Where did they land? How many people were aboard? Seems like pretty basic information. But the government's position is that if they were to disclose that, even under seal to the judge, that it would reveal secrets that would, as they say, directly compromise the safety of American officers, contractors, aliens, and the American public on the one hand, and on the other, that it would reveal non-public, sensitive, and high-stakes negotiations with foreign governments.
It would also reveal whether or not they disobeyed his order. I mean, that's what he's looking for here. When did they leave? Was it after I gave the oral order? Was it after I gave the written order?
Correct. Just to be clear, on Saturday afternoon of March 15th, he had a hearing in which he directed the government to make sure that any planes that were in the air had to turn around and return to the United States. He did that orally, and maybe a half hour later, he issued a written order that did not include that directive. And the government's taken the position, well, it wasn't in the written order, so we don't need to obey that, and we would only follow what's in the written order, not your oral order.
He has said that he wants the Venezuelan plaintiffs to be able to have due process.
Correct. I don't think that he believes he has jurisdiction over the people who already have been flown to El Salvador, but there's something like 250 other people who are potentially subject to the Trump proclamation that says that if they're members of this Venezuelan gang, that they are subject to immediate deportation under the Alien Enemies Act of 1798.
And no one has yet ruled, no court has yet ruled on whether Trump's invoking the Alien Enemies Act, which has only been used 3 times, always in wartime. No court has actually ruled on whether that is legal or not.
They have not ruled on the merits of the objection to the use of the Alien Enemies Act in this context, being that the United States has not declared war against another nation, which is how it had been previously used in U.S. history.
So now let's turn to the next level of court, which is the D.C. Appellate Court. There was an oral argument there yesterday in this same case.
Well, the basics of the argument were, did Judge Boasberg properly exercise his authority in putting a pause on this order to deport these alleged Venezuelan gang members? There was a Trump-appointed judge who had serious problems with what Judge Boasberg had done and believed that the case should be moved to Texas so that individuals could litigate their own case through what's known as a habeas corpus petition. And there was a Democratic-appointed judge who felt that the government's position was quite deficient. There's a third judge who did not express an opinion, and so it's a 3-judge panel. It's hard to know at this moment just how it will go, but it seems pretty clear that this case is headed for the Supreme Court.
And so one of the judges, the Democratic appointee, Patricia Millett, said that Nazis got better treatment under the Alien Enemies Act during World War II than these Venezuelans because they were deported without any due process.
Right. There was a procedure for deporting Nazis at that point. There were panels that were set up. In this case, the Trump proclamation was publicly announced maybe an hour or two before the planes took off. That's what it appears from the available public evidence. And so they had no real chance to challenge it. The litigation that we're talking about arose because the ACLU and another group filed preemptively because they had heard that Trump might invoke the Alien Enemies Act, and they wanted to foreclose the possibility that it would be used against 5 plaintiffs. And in fact, Judge Boasberg granted a temporary restraining order with respect to those 5 plaintiffs, and then he granted class action certification for everyone else who might be affected by that order.
All right, so let's turn now to a totally different topic, the trial of Bob Menendez's wife. Is it basically the same case, same witnesses, same evidence?
Nadine Menendez went on trial yesterday with opening statements in federal court in New York. It's essentially the same case that led to the conviction of her husband, Bob, the New Jersey Democrat who used to be the powerful chairman of the Senate Foreign Relations Committee. The case that the prosecutors laid out in the roadmap for the jury was that she acted as a go-between between her husband and 3 corrupt businessmen that were seeking favors, as well as the Egyptian government, and that in a raid on the house that the couple shared in Englewood Cliffs, New Jersey, the FBI found 13 gold bars, a black Mercedes-Benz convertible, and more than $400,000 in cash, nearly $500,000.
So is the defense going to be that she didn't know or intend to violate the laws?
Her defense attorney's opening statement was that essentially she did not have the knowledge and intent of the crimes that's necessary to convict her of all the counts against her, which includes bribery, conspiracy, fraud, extortion, and obstruction of justice.
So her husband blamed her. Is she going to blame her husband?
That's not clear yet, but her husband essentially said at trial that she received a lot of cash in gold bars without his knowledge from these businessmen who she had known a lot longer than he had. And so they had a prior relationship, and Bob was unaware of that and became aware of that as time went on. And Bob Menendez also argued that he was unaware of the extent of her financial problems, which complicated her life and led her to need a new Mercedes-Benz and other considerations.
So Jose Uribe, who testified against Menendez, is going to testify against her?
Uribe is going to testify. He is going to say, I would expect, that he gave Nadine Menendez $15,000 in cash in the parking lot of a New Jersey restaurant so that she could buy a Mercedes-Benz, and that he made monthly payments on the car for something like 3 years. In exchange, the senator made a call and had a meeting with the Attorney General of New Jersey at the time, trying to suggest that the New Jersey Attorney General should drop the criminal investigation of two people who were close to Uribe.
So just because he was convicted, it doesn't mean that she'll be convicted.
Right. It's a conspiracy case, and now several of the conspirators have been convicted, 3 at trial and 1 by guilty plea, but that doesn't necessarily mean that she's guilty. The government's theory is that she was critical to the conspiracy because she made key introductions between her first boyfriend, now husband, Bob Menendez, and the 3 people who bribed her, and that, she actually received the bribes.
Now, Bob Menendez at this point is angling for a pardon from Trump?
We have reported that he is pursuing a pardon. He's been a Democrat his entire career and has been quite critical of Trump through much of his career. He has started to echo some of Trump's language in his statements about how he was the victim of a witch hunt and prosecutors who went out of their way to persecute him without good cause.
At this point, he's blaming the government for putting her on trial when she's recovering from cancer?
She has had and is fighting breast cancer, and she just recently had breast reconstructive surgery. She felt that the trial should have been delayed, and the Judge Stein in the Southern District of New York decided to go ahead with the trial after separating her from the other defendants who went on trial with Bob Menendez and granting her another delay. He finally said, enough is enough, we're going to trial.
How long is the trial expected to last?
I believe it's supposed to last 8 to 9 weeks, so it's going to be a marathon, and the prosecutors have promised that they'll try to streamline the case. In the first trial, there were 3 different sets of attorneys that could cross-examine witnesses, and here there's only 1. So you would think through that alone, it should cut back on a good amount of time that the jury will spend in the courtroom.
I know you'll be following it. Thanks so much, David. That's Bloomberg legal reporter David Voreacos. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.